Hello, everyone. We are about to begin our second session, and we're still in the ELI's focus area, sustainable life and society. But now we turn to our second pending project, which is Ecocide. And given how the discussion looked during the previous panel, I will give no further introduction, but I will pass the mic to Professor Pokar, who is Professor Emeritus of International Law at Milan University. He's been an ad hoc judge at the International Court of Justice since 2017, member of the UN Human Rights Committee from 1984 to 2000 and president for 2 years, a judge at the International Criminal Tribunal for the former Yugoslavia, an appeals judge at the International Criminal Tribunal for Rwanda, and ELI member from 2019. And he is here as a co-reporter of the Ecocide project, and he will present the project to us.
Thank you, Anita, for giving me the floor on this, to introduce this project in a few minutes. So I will not be able to go into details, but to explain the reason for this, the basis, the background for this project. We heard, this is linked in a certain way to the panel we had before, because when discussing climate change has an impact on the environment, and ecocide is a crime, or a proposed crime, to deal with violations of from the criminal point of view, essentially. At least the project is essentially on criminal law, although there may be in the project some aspects that, especially on the sanctions, that may concern civil law. The consequence, deal with the consequences of the violation, and go to reparation as far as this may be possible in a given situation. Now, on this matter, this project is not the first project that exists. We have, on one hand, and that was when we started, a point that we had to take into consideration. On one hand, we have a project to insert a new crime, international crime, in the Rome Statute of the International Criminal Court, dealing with the violations, criminal violations that concern the environment. And this has been an initiative that's been taken by an NGO, and has already produced a project with a definition of the crime and the indication of where the crime should be put in the Rome Statute of the International Criminal Court. That's one thing. On the other side, we have a number of initiatives, in particular within the European Union, to criminalize violations of the environment of a certain gravity. And we have, in particular, a proposal now for a directive of the European Union to deal, to criminalize, to recommend, of course, under the directive to states to introduce in their legislation certain crimes concerning the damage created to the environment. And so we already have these two sides. One point is that the initiative, the international initiative for the Statute of the International Court of Justice, goes to define the crime of ecocide. The European initiative does not take in the definition at all, so does not consider the definition, spells out a number of behaviors that should be criminalized, conducts should be criminalized if put in place, but does not use the term ecocide ever, except in a proposed recital in which it says, well, these conducts should be criminalized and in grave situations may even amount to ecocide, but does not go to ecocide. So where to put our project of the ELI? This is the real point. On one hand, of course, we are not against introducing a crime in the statute of the International Criminal Court. We may discuss the proposal that has been made, but that would be to amend it, and many others are doing that. Certainly when we will put to the Assembly of States Parties for adoption, there will be amendments. It's inevitable. In an international conference, you always have amendments to the project, to the proposal. So this is, would be one action that maybe it would be a limited action of the ELI to amend that notion. On the other hand, we are a European institution working in European Institute, and so we have to find a way of doing something concretely. Also taking into account one thing that has been already flagged during the previous panel, that we have to take into account the areas that create more problems from the environment. We sometimes tend to accuse certain countries, and it's correct maybe to do it, but we have not to forget that in terms of impact on the environment, Europe is doing a lot against. It's doing a lot for, maybe taking initiatives for, but also the endangerment to the environment comes mainly from the most developed countries in the world. This is a fact. The scientists have put clearly in place. So it's Europe and the United States on the other side. So this is the problem. So we have more responsibility also to do something to remedy the situation. So where to put our proposal? We think we should not renounce to have the word ecocide, to have a crime ecocide. Because ecocide words have a meaning at the end. And when you criminalize a conduct, it goes to the people, it goes to the society as a whole. The stigma put on a person for committing a crime is different, depending on the denomination of the crime also. We have several examples that in the history, you may speak of sexual assault, or you can speak of rape. If you don't use the word rape, it's different. It's having only sexual assault. It's important to have the name. So we want a name. And so we go to define the crime in our proposal. On the other hand, we take into account the efforts of the EU and want to impact on the efforts made in the EU to criminalize activities contrary to the environment and damaging the environment, but denominating ecocide at the same time. So when it is more grave and fall into our notion of ecocide, states would have to call it ecocide, and not only a crime against the environment. Now, I cannot now go into the details of this, but I wanted to give the general approach to the project. Thank you.
Thank you very much. I beg for forgiveness for being strict. And now it's turn for Anais Berthier, who is a senior lawyer and head of EU affairs at the environmental law charity Client Earth. At Client Earth, she set up the Environmental Democracy Program, and for many years led the Client Earth's work on strengthening the rule of law. The floor is yours
Thank you.
for 9 minutes.
Yes. Okay. Thank you. Thanks to the European Law Institute for the invitation. I'm really happy to be here with you this morning and to share some of our thoughts and work. So just for those who weren't there before, Client Earth is an environmental NGO that is exclusively composed of lawyers. And so we have 8 offices in the EU, but also beyond in the US and in Asia. And so we do bring strategic litigation, but also we advocate for ambitious legislation, both at EU and national level. But this panel is about Ecocide. I won't go into the details either because it's been presented, but just wanted to raise a point, and going to be a bit provocative here again, is that I think that the creation of this new crime would pose the question, the broader question of the level of effectiveness of criminal law in addressing environmental damage. And I think there is consensus, or at least maybe we'll see at the end of this session if there is, that there is a lack of effectiveness of criminal law to protect the environment. The use of criminal law to address environmental damage is actually marginal. The European Commission has also acknowledged the fact that despite the seriously damaging effect of environmental crimes, current rules just do not tackle them effectively enough, and so they have revised the Environmental Crime Directive and found out that the directive was not actually fulfilling its objective, and so the revision is ongoing at EU level. So we think that this lack of effectiveness of criminal law has several reasons. First, the lack of trained judges, experienced judges and prosecutors for this type of litigation. Second, the level of penalties is quite low and disappointing in environmental cases, and thus not dissuasive enough. And when working with judges and prosecutors, the feedback we get is that actually the fact that they're dealing on an everyday basis with crimes such as rape, murder, torture, you name it, somehow environmental crimes are not seen as serious than the other type of crimes, which explain to a certain extent the low level of the penalties that are imposed to environmental crimes. The level of evidence to bring is really high, and so really difficult to bring in environmental matters. The delays are way longer than in administrative cases, and that's a problem in relation to the establishment of a culture of compliance, and is not fit to address the climate and the biodiversity crisis, which, as we said this morning, needs to be dealt urgently. And so we witness in really several domains, just like in illegal fisheries, for example, that the administrative penalties and system is way more efficient. And the reason is that the administrative police has a way better and finer knowledge of the matter, and then can really identify the damage way better and then assess the right penalty. So for all these reasons, I think that EU environmental NGOs have the tendency not to prioritize criminal law to tackle environmental problems, but we must recognize that the proposal for a new crime of ecocide has been really successful in attracting and steering debate, discussion, and has gained traction and shown that there is a real interest among the population, the media, to at least address the violation of environmental legislation. And so maybe it will contribute to reinforce the use of criminal law. And so I think that at EU level, we'll definitely see that, whether it's the case with the new Environmental Crime Directive. However, one of the concerns we have is that even if ecocide was to be in the operative part of the directive, it would still face all these issues that there are in relation to criminal law in environmental matters. So what we mean is that criminal law does have a role to play, but it needs a lot of work still to be effective and efficient in environmental matters. So I thought, if I still have the time, 4 minutes, I thought I would give you some examples of the type of litigation we do, both at EU and national level. And our main aim is really to ensure that the bulk of EU environmental legislation that is huge already is properly implemented and enforced, because that's actually the main problem we have. The law is there. Of course, it can be improved, and it is being improved to a certain extent, not always the case at EU level, but it needs to be better enforced. And so first, at EU level, we mentioned it a bit before, we fought a lot to broaden the scope of access to the Court of Justice of the EU for NGOs and individuals. And so we won that case before the Aarhus Convention Compliance Committee, where the EU has been recognized in violation of the Aarhus Convention. And so now the Aarhus regulation has been revised, and we can challenge way more acts adopted by European institutions. One example is that delegated act adopted by the European Commission to qualify gas as sustainable and as a transitional activity under the taxonomy regulation, which is the sustainable finance law at EU level. And we, of course, think that that decision violates several other EU pieces of law. So that's legal arguments, really specific, including the EU taxonomy regulation itself, so the basis for that delegated act, but also the European climate law and other EU international commitments undertaken by the EU. Another act that we are challenging is, for example, the setting of fishing quotas by the Council that hasn't been taken into consideration the relevant scientific advice. And we also do push to get more access to justice and enforcement provision into sectoral legislation. And so, for example, we're really happy with the European Commission's proposal for a revised industrial emissions directive, which includes several new proposals and changes to the current framework. And one of them is to introduce a reversal of the burden of the proof to benefit the victims of the pollution. So that has never been done before within the EU environmental law framework. And that would mean that industrial operators would be presumed to be liable for the health damage caused by the activities that would be in breach of the Industrial Emissions Directive. So we really hope it's going to remain in the final text of the directive, and that the Council is just not going to get rid of it, as usual, unfortunately. And we also do have cases against corporations, of course, as the main polluters, and some cases that may be considered as climate cases as well. And because we think that litigation sends a strong market signals, of course, to companies. Our two most recent cases are greenwashing cases. So that's another legal ground that we can base ourselves on in climate cases that is really specific and really legal, and is not asking the judge to outpass their powers or to change the separation of powers. No, on the contrary, there is a law, and we are based ourselves on the directive, on the Unfair Commercial Practice Directive, to tackle greenwashing. And so we have a case against KLM, against Total Energy, and another case against Shell based on UK company law. So just to show all these different legal grounds that we can base ourselves on, and on these cases that can also be called climate cases. Thank you.
Thank you. Thank you very much. And now we turn to EU law. And our next speaker is Mr. Antonius Menders, who is a lawyer and a politician representing the CDA in the EPP group in the European Parliament since 2019. But he has been, it's his 9th term in the Parliament, so he knows what he's talking about. He is a returning member of the Committee on the Internal Market and Consumer Protection, and a substitute member of the Committee on Employment and Social Affairs and the Committee on Legal Affairs. And he will talk about the revised EU directive on environmental crime, and will give us a feedback on the project. Yes, we are. Yes, he's online. Welcome, and the floor is yours.
Thank you very much, and thank you for inviting me. Thank you, European Law Institute. I'm not a scientist. I'm just a simple lawyer, and and an MEP, and I was 20 years ago, I was the rapporteur already on the Environmental Liability Directive, which is not used often, and that's a little, well, that's a pity. We are talking now, I'm the rapporteur on the Environmental Crime Directive, which means, well, it's an extra chapter on the criminal law in Europe. And we are facing now climate change. We need to introduce more precaution to avoid damages to the environment, and until now the environment is not taken seriously by the industry, and I think it is very important to extend this environmental crime directive. It's not possible to make it a regulation out of it due to the treaty, but we want to harmonize it as much as possible. I'm working on it now, and we are talking about heavier sanctions. And if we talk about a fine, then we talk about, at least that's my goal, a target fine, that we can use the fines for recovering the damage that is being caused by an environmental crime. Also, what I want to focus and to introduce more and more is penal and civil liability for corporate board members in certain circumstances. If they knew and they, let's say, they adjust the environmental crime just to make more money, just for money reasons, then I think they should be taken to court. And I give, most of the time, I give the example of Martin Winterkorn, the CEO of Volkswagen, who did by purpose asked his engineers to introduce fraudulent software just to hide the environmental damage, and he's taken to court in Germany too. What I have said, it's important to introduce more prevention, because that's the goal of the whole thing. I don't think that society will get an advantage of putting people in jail, but it is to avoid environmental damage. It would be nice to facilitate, to introduce a sort of an compliance officer for environmental damage for multinationals. Perhaps they have already, but they should also be a sort of a whistleblower, and they need to be protected then. What I also want to introduce is a parental the parental liability, and that you cannot hide behind a legal person, like Shell now is doing they are polluting Nigeria, and the board of Shell said, no, this is not Shell, it's a legal person which is owned by Shell. So I want to introduce a parental liability too. We focus on more harmonization. Now, the most important thing, because the professor said there is no definition of ecocide. I think we should have an international definition supported by the United Nations, and then we could take that aboard on the legislation. So we are open for a definition of ecocide, but personally I'm very against the fact that every country will have its own definition for ecocide. Environmental damage is, most of the time, it's a cross-border. It's happening cross-border, and then you also need a sort of, let's say, a European prosecutor, a public prosecutor who can take these cases to court, because member states are not happy to do so, because they also always talk about employment and of course prosperity and economy, but the main fundament of our economy is the climate, and so we have to be very careful and prudent with that. Um, so what also is known that um, the environmental crime worldwide is in the top 5 of the most lucrative crimes after human trafficking and drugs. So we have to do something. Tomorrow I will visit Eurojust in The Hague because I think, according to the treaty, they can become the public prosecutor for environmental crimes, and I hope together to work together with Apple. But then we have to give access not only for the member states to Eurojust to ask them to take action, but I think also that, for example, local governments, but also NGOs should have the possibility to go to this Eurojust and pointing out where an environmental crime is taking place, so that they can act if member states are not willing to do so. So again, Ecocide. As a rapporteur, I'm not against Ecocide, but then we need, let's say, a global definition which is recognized worldwide. Because how can we take, for example, Shell to court with a European definition of Ecocide if the crime has been committed in Nigeria or somewhere else? So I hope that the UN, that they come forward soon with a supported definition, and then, of course, we are happy to adopt that too in the Environmental Crime Directive in Europe. At the moment, this is the most, these things, things that I want to say are said. And it's nice to see in the audience my former colleague from Portugal. He's reading a book now. But that's no problem. I'm open for questions, so please be my guest.
Thank you very much. We will open the question panel after the last presentation, which will be given by Rodrigo Ledo, who is a human rights lawyer from Chile, currently director of the Baltasar Garzón International Foundation and professor at the International University of La Rioja. He was one of the members of the independent expert panel for the legal definition of ecocide in Chile. He was also head of the legal area of the Human Rights Program for the Ministry of the Interior and worked in the National Commission on Political Imprisonment and Torture. And the presentation will deal with the proposal of independent expert panel for the legal definition of ecocide. The floor is yours.
Well, thank you very much. It's a real honor to be here in this wonderful annual Congress. What I'm going to talk about is just few words about the independent expert panel for the legal definition of ecocide, and the work of the panel, and the definition itself achieved by the panel. So first, the panel. Why the panel? So Stop Ecocide Foundation realized that there were many initiatives around on the table. So they decided to focus on a new definition, a new legal definition, which could be applied by the International Criminal Court right now, because it is urgent. This is the conception behind the initiative. So the panel has a gender balance, racial and ethnical inclusion, continental representativeness, representativeness of legal system, common law and civil law, of course. The members of the panel are experts in international criminal law, environmental law, are academics, former judges for the ICC, former ICC prosecutors, UN officials, expert litigants in international and national domestic courts. So about the panel work. So the panel meets for 6 months. The panel was assessed by external experts also. A public and global consultation was developed. Remarkably, the concept of dolus eventualitatis is already used by the definition, comes from this public consultation. So, well, finally, the panel reached an agreement about the definition. But allow me to confess that it was very, very difficult task. Not was easy task, due to the enormous diversity of the members of the panel. Yes, of course. At some point, we even think that it would be necessary to vote. But finally, it was not the case because we reached a definition by consensus. The key of this was a balance. Balance and I call intellectual generosity. That means everyone was open to understand the point of the others. It was a very nice experience indeed. For number 3, the definition is, if I have time. Well, some general comment about the definition. The definition pretends to be applied by the ICC, not by domestic court. So if you want to apply by domestic court, maybe some changes. You must introduce some adaptations. Yes, because the systems are very different. So the second general comment is intend to be adopt an ecocentric or biocentric approach, not anthropocentric approach. It does not pretend to be neither the only, neither the first, neither the best measure to protect the environment. Of course not. Nor does it exclude other environmental crimes. It is only an intent to have a definition to start the debate in the ICC Assembly of States Party. But the definition is a result of an agreement between 12 people, very diverse experts from all over the world. So you, of course, can make change and can improve this definition. Even you can say we make some mistakes. Of course, we are not infallibles. But we must have a very good argument to do some changes. So we propose 3 changes in the Rome Statute, a new preambular paragraph, this is very, very new, a new preambular paragraph, to adopt a biocentric approach. Second is the amended Article 5, of course, because Article 5 is about crimes within the jurisdiction of the court. And third is a new Article 8 ter. Could be 6 bis or 7 bis, but we adopt 8 ter. So about wording in the definition. It's a new definition, yes, but it's built with an old bit from international treaty, customary law, and jurisprudence. So about the structure, the definition has 2 paragraphs. One, define the crime, and second, define the terms of the crime. So definition of terms. So paragraph 1, here is the core of the definition is, ecocide means unlawful or wanton act committed with knowledge that there is a substantial likelihood of severe and widespread or long-term damage to the environment being caused by those acts. So paragraph 2 defines thresholds and the protected legal good or protected legal interest. So that what we want to protect, which is environment. So what about threshold? We have two groups of threshold. One group is focused on the damage, and the other is focused on the action itself. Threshold 1 is the damage must be always serious and must also be either widespread or long-term, or both, of course. That is, we choose 2 of 3 elements. Threshold 2, the action or omission must be unlawful or wanton. Wanton means reckless disregard for damage which would be clearly excessive in relation to the social and economical benefits anticipated. So wanton is a term already used by the Rome Statute in the Article 8 as a war crime. So they say, the statute say, not justified by military necessity and carry out unlawfully and wantonly. So if you notice, here is a balance. The definition expand, they already exist in the international criminal law, but at the same time restrict with the threshold what is admissible for the states. So some few words, if I can, about mens rea. Fortunately, I like to say that, Fortunately, there is not a billion who, night by night, is planning to destroy ecosystem or destroy the planet. So, dolus or direct intent is not the case. It's not an issue in this crime. What usually happens is the desire of companies to obtain economic benefits, and sometimes they carry out risky activities without adopting the necessary measures to prevent potential environmental damage. So the panel agreed to extend mens rea that is already included in Article 30 of the Rome Statute. So the panel explicitly say in their commentaries, recklessness or dolus eventuali is the subjective element in the ecocide. So this is very, very new, very disruptive maybe. So about endangerment, I am finishing, I promise. About the endangerment. So ecocide is an endangerment crime because we need to prevent, yes, of course. Like genocide is defined based on the act or omission and not by the result, the consequences. That is, it anticipates the penalty at the time of the commission of the endangerment act. See, the similar construction you can see in the Rome Statute in the war crimes, in the concept attacked. So final words about the definition. We receive, the definition received many supply for different countries, UN Parliament and Commission, UN's General Secretary, Pope Francis also, and many members of civil society, but it is not a reality right now. So about maybe ELI project and other initiatives to adopt this definition in the domestic legislation. I think that is a very good idea to adapt this definition, for example, in some points. For maybe more definition of terms you need, because the legal principle. And you need to harmonize the criminal law and environmental law with this definition. Liability of legal persons. We avoid, the panel avoid this topic. Negligence as a subjective element, maybe why not? Aggravation of the penalty, in the case in which the harmful for the environment is carried out. Yes, that's it, my speech. I'm sorry for the time. I'm sorry for my poor English also. Thank you very much.
Thank you. Thank you very much.
Thank you.
And we begin a Q&A session with intervention by Robert Bray, who is already notified himself like 20 minutes ago. And since he's also a co-reporter in this project, we give him some privileges. Robert?
Thank you very much, Anita. Can you hear me?
Yes, we can hear you. We cannot see you. No,
Cannot,
okay.
You cannot hear?
We can hear you. Very well.
Okay,
Thank you, Robert. Go on.
I would like to make five very quick points in response to Ms. Berthier's interesting arguments about criminal law. First of all, we consider that creating or recognizing the crime of ecocide will be very symbolic. Yeah? It will be a very symbolic and deterrent gesture. I can imagine a day when there may be a new Nuremberg trial to try people that have destroyed our environment. And I agree very much with Twan Manders that the way to do this is to get after the corporate officers that are responsible for this. Secondly, we are proposing, or we're thinking of proposing, that ecocide should be an autonomous crime. That is to say, when the elements of the crime are made out, it will not matter that the perpetrators had the benefit of a license or an authorization or a permission. It should be an autonomous crime. The next point I would like to make is that environmental crime is very much linked with organized crime generally. And in many cases, where indigenous people are involved, it is approaching on genocide. So the gravity of the crime is certainly there. My next point is that we are also proposing model rules for the involvement of the European Public Prosecutor's Office, so as to allow indigenous peoples and NGOs and others to bring proceedings with the assistance of the European Public Prosecutor's Office. Lastly, I would also point out that in a second stage, we are going to come out with proposals for civil law. Civil law, as Ms. Berthier pointed out, it's often more effective and quicker than the criminal law. You can go for an injunction, for instance, which can be highly effective. And I would just point out there's been a recent case, to my surprise, of the 8th July, where the Court of Appeal in England has allowed a group action, group litigation, in a case called Municipio di Mariana, involving litigants from Brazil, which is a very interesting development. Interestingly, the courts are often prepared to go, as the European Law Institute pointed out in its report on supply chain liability, the courts are often prepared to go where politicians dare not. Thank you very much for your attention.
Thank you very much for these encouraging words on the judges. And the floor is open for questions. Yes, so first, please, and then here.
Thank you very much. Very interesting contributions from everybody. Can I just sound a little note of caution about the role of the European Law Institute? I'm a judge, a serving judge, and in fact I decided part of the Mariana case, which has just been referred to. And I think it is very important. We're going to be talking about judicial independence shortly. And obviously it's very important for the judicial members of ELI to be entirely independent. And some of the language used in the question of whether ecocide ought to be made an offence by the European Parliament is in the nature of political debate. And all I would say is we must make sure that the European Law Institute, which is respected internationally for its contribution on strictly legal questions, does not descend into the fray or the arena of political debate, because that would make it embarrassing for its judicial members. And I've decided numerous cases involving climate change in my jurisdiction, and I don't want anybody to say that I'm a member of an organization that has a political part to play. And so I do hope that we will bear that in mind and we'll stick to the kind of debate that Professor Lado was talking about, namely how such a thing should be defined if politically it was decided to have such a crime. But nonetheless, I'm fascinated by having heard what people have said.
Yes, thank you very much. And okay, so please, and then. Please introduce. Could you please introduce yourself? Okay, so everyone knows that will be.
Okay, hello. My name is Marina, and I work in a consultancy in sustainability and climate change. I wanted to thank you all. It was really, really interesting. I wanted to ask, hearing Rodrigo Yo's intervention, here you talk about the biocentric approach in the Rome Statute. I was wondering, how would the rights of nature movement present in some constitutions in Latin America, Ecuador, Bolivia, and at local levels in different ways, how does the rights of nature movement tie in with the notion of ecocide, and is there a potential of the movement to somewhat contribute to developing the notion of ecocide? Thank you.
Okay, let's gather questions. It's difficult to hear you.
Thank you. This is Ilaria Pretelli.
Yes.
And I would like to thank all of you. And but I think that there is a distinction to be made between climate change, ecocide, and corporate liability. We have seen a lot of sectorial legislation, sometimes incoherent, and I think I would like to ask Professor Pokar to clear a little bit and explain to us better what is the definition that we are going and we are working on in the group, because I think the audience deserves to know a little bit more about that. Thank you.
Yes, and one more question, and we answer, and then round again.
Thank you. I'm Walter Doralt. I'm a professor in Graz. I'm very interested in the topic because it touches upon the corporate world and the duties we wish to impose on directors and officers in companies. And in that context, I wonder how will the interests of companies be taken into account? To a degree, what we've heard so far can also be seen as a new project or a new venture in spearheading needed change. But if I understood it correctly, at some point, I think in the last presentation, we were told, even if all public law duties of a nation are fulfilled, if a company abides by all those rules, they should still be liable. Now, if we want to impose criminal sanctions on those people who call the shots and make the decisions, and we want to have criminal liability, I think there's two aspects that will need to be taken into account. One of them is it would need to be a clear-cut definition of what exactly can still be criminal as an offense, in spite of respecting all duties wherever the actions occur or the damage occurs. Because what we cannot really argue for is to have a very wide-ranging criminal liability without exactly saying what is criminal, in spite of all local administrative rules being respected. At some point, of course, we want rules to protect the ecosystem more, and if needed, criminally. But at some point, we also need to take into account the interests of those that we want to regulate. And they need to be able to predict, where am I beyond crossing the red line and where not. Now that is a risk, and with that comes my question, how will that be taken into account also in the project and in the work ahead? There's a risk if the corporate world is not included, and it doesn't need to be a lobbying organization or think tank, but it ideally would need to be senior directors or previous directors who actually can also add to a degree how decisions are being taken. And I think one key may very well be creating the incentives, in other words, making it extremely costly through sanctions if there is an ecocide. But I think that's really a risk, because so far from what I could hear is best intentions, but to make sure that we impose a criminal sanction without really seeing that people who then will be subject to those regulations need to anticipate what is criminal. Thank you.
Thank you very much, and let's give answers.
Should I?
Yes, please.
Thank you. Well, there's been a lot of questions to be made by my colleagues and by the public. Let me say one thing. It has been challenged that ecocide, the notion of ecocide, should be adopted at the European level and domestic level. Dr. Manders has raised this point. I mean, it's an important point because it goes to the heart of the project. I mean, I think this is completely wrong. 100%, I think is wrong. The idea that the notion of a crime should be adopted universally only and not at the national levels. In other terms, when you have a crime, you cannot say, I make it an international crime only, and it's not necessarily a domestic crime at the same time. And you come to the conclusion that a state or a group of states, like it is the EU, cannot domestically take care of that crime. Because if you don't do that, forget about punishing a crime. It's simply that. Giving it only to the international court means not having any result. It's clear. The statute itself of the court says the adopted principle of complementarity. The priority in jurisdiction is of the states. If the states don't do it, then the court may intervene. So having an idea that you must start only for the international level is simply wrong. And if this is the position in the European Parliament, I think it's a wrong position, simply. And should be, we should go against that, clearly, and have the Parliament change their view. And in a way, this gives strength to the idea of our idea that certain crimes, certain types of violation should be denominated ecocide at the domestic level, European first, and then domestic level. That's also the logic of the statute of the court. Now, on the question of why having that also and not waiting, as they have been maintained, only the international level first, is a question of timing. If the EU adopts a directive and establishes 2 years, 1 year, for the adoption at the domestic level, you have the crime at the domestic level. This will never be the case for the International Criminal Court, let's be frank. I worked 40 years in the United Nations. The times of the United Nations are not times that allow for making quick decisions. The Assembly of States Party will have to adopt the change, and I'm very favorable to the change, but what time will be necessary for that? Then it has to be ratified by the states. Other time will be necessary. An assessment may be made if it goes very, very quickly. It's accepted tomorrow, in 10 years we will have the crime. If not, will be 20 years. Is that a reasonable time frame? In my view, it is not. With the EU, you can arrive much earlier to have it. So it's a reason of timing, simply. Otherwise, we could wait for the definition to enter into force, and of course, it has to be adapted, but I don't want to go into the adaptations. On the question of the responsibility of the corporations, I'm quite, our project is dealing with that, and I quite agree that there should be a strict definition. Because one thing is to have a crime at the international level which doesn't deal with the corporate responsibility, by the way, but could do it, and have it in the domestic level. This is just for constitutional reasons. If you work in the international environment, you apply international law. You apply, to a certain extent, even customary law, even when you apply treaties. And you have a certain flexibility. Let's be frank. If you are in a state, you have a principle of legality which is much stricter. And the interpretation, you can do something but not go, I agree with the speaker, can go beyond a certain limit. So you need some elements of the definition that are stricter than at the international level. And that's another reason to have a statute at the domestic European and domestic level, I think. But the rest, Anais has also mentioned a lot of restrictions that are necessary, or in terms of evidence, in terms on how to deal with the case, to respect principles that are constitutional in the member states of the European Union. That's quite clear. Thank you.
Thank you very much. You would like to? Yes, and also. And just to clear, Mr. Manders, you would like to reply as well in this session of questions?
Yes, as always, but first I take the opportunity to say hello to Manuel Ortega, my colleague who's in the meeting room under the audience, and also Robert Ray. I know them. We work very, very well and long time together. So good to see them. Now coming back on the Ecocide, we are talking about serious, but what is serious? If the word, the name ecocide, I compare a genocide. And if I know that the last 100 years, there are, I don't know how many genocides there were in the world, but perhaps 50. So do we need then specifically for this a definition? Because I think if we are talking about ecocide, even without a definition, we know that it's sincere, serious damage to the environment. And I think we have tools enough to work on that. Legislation had to be clear. And for example, if you use the word serious, what do we mean then? That's serious is very, I always said it's work for lawyers to discuss words like serious and other things. It's difficult to make legislation which is so close by definitions and lists that is easy for a judge to take a conclusion and to give a judgment. That's why there are so many lawyers everywhere in the world to contest all the arguments which are bringing forward. So I think let us make the first step. Let us try to make it a crime, environmental crime, because most of the countries, even in Europe, they don't have a proper environmental crime legislation. And let us first start with that, and then it will evaluate into a real addition to the penal crime laws in Europe, and that it will evaluate. And then I think we can avoid more damaging the environment, and we can stop, for example, a little bit the climate change. We can stop the killing of all insects, and we can work in a better future. Thank you.
Thank you very much. Professor Reda.
Yeah, me. In 8 minutes, it's very difficult to summarize 6 months of works of the panel and the definition. So paragraph 2 has a letter A, B, C, D, E, etc. And the commentary is at 12 pages. And believe me, we discuss about every single word in this commentary. Yes, because it's not the definition itself, it's the definition and its commentary. So I will try to explain something more about the questions. Prevent and political debate, I am absolutely agree, but right now we have a definition. We can have right now legal discussion. So about right of nature movement, an ecocentric or biocentric approach. Yes, the panel was in contact to indigenous people with many civil society members, even including right rights of natures. Yes, but it is not necessary. We think that it's not necessary to go so far, saying that the nature has right. That it's only necessary to say that nature deserves protection itself. That's it. If you want to say more, as a Bolivian constitution or Ecuador constitution, maybe the failure project of new constitution in my country, you can say this. Yes, many jurists are adopting this conception. But in this case, for this definition of a crime, it is not necessary to say this. Just say the nature deserves protection itself. Not because we live in the nature itself, okay? About corporate liability, yes, we avoid this debate because it's a very huge debate in the International Criminal Court. And when the International Criminal Court opened this melon, we can say this in Spain, open this melon, of course, ecocide will be in the discussion. But the our proposed is to include Ecocide in the Rome Statute right now. So we don't want to enter in this big discussion. So about companies, yes, it is interesting. It is not in the commentary, but we talk about that maybe companies needs time to adapt their production, the procedural production. So you understand, sorry, my English, to adapt to this new regulations. Yes, but we take into account what happened with corporation and what happened with the states. Let me say another confession here. In the beginning of the second meeting, maybe, we noticed that we were divided in two groups. Some of us were more progressive and some of us were more conservative. Some of us think about the principles and some of us think about the consequences. How could be possible to adopt this definition, to pass this new legislation? So remind me the Max Weber dilemma. You know Max Weber dilemma, the German philosopher. So, well, we resolve this dilemma with balance. It's a well-balanced definition between what do we want to protect and what is possible to approve by corporate and states. So we take into account. Yes, of course, need more development. Yes, maybe, yeah. But I think it's very clear because every single word is defined in the commentaries. So about adopting in the internal legislation, there is an Argentinian initiative that is very interesting. They already adapt this definition to a legal proposal to pass a new crime to include in the Argentinian criminal code. So it's very interesting process. So I take some notice about this project. For example, negligence or other definitions, more definitions or more precisions, of course. Well, that's it.
Thank you very much, Anais.
Thank you. No, I will have a bit more practical remarks. I agree it's a question of time, but also of political will. Is there political will to ratify the amendment? I think you need a huge number of states parties to the International Criminal Court. At EU level, I think the European Commission is adopting a bit of a cynical position, saying until nothing is solved at international level, we are waiting to see what we will be doing at EU level, which is a way to say thanks but no thanks. And so the opportunity to include Ecocide at EU level is really the revision of the Environmental Crime Directive. And thus the need for a very specific definition to be able to, if it was the aim of the European Law Institute, to push for it, because otherwise it's not going to happen. And I think there is a bit of a confusion within the NGO community at EU level because of this lack of specificity in the definition that needs to be proposed and pushed for to do advocacy work, basically, and to discuss with the European institution. And so now the ball is with the European Parliament. And so it remains to be seen whether, if there is a specific enough definition to push for, whether the European Parliament will be willing to table it, and then whether the Council will be willing to support it. So that's the stage I see for Ecocide to exist at EU level. And I agree in relation to corporate responsibility that, of course, there is a need for that very specific definition to ensure that there is legal certainty. And at EU level now we have another directive proposal that is being discussed specifically about that, not criminally, but that's the Corporate Sustainability Due Diligence Directive proposal, which is really interesting because it creates due diligence obligations for companies to identify, to stop, and to mitigate their impact their economic activity has on human rights and the environment. But is also proposing for a new civil liability regime and for directors' duties as well, and for penalties imposed to directors as well, and to companies. So that's also a hook that I think is really interesting to seize and to work on at EU level right now in relation to corporations' liability.
Thank you very much. Unfortunately, we run out of time. So there's going to be only one session of question and answers. And I would like to take last 60 seconds to conclude those two panels, which go under the Sustainable Life and Society umbrella in ELI. Those are two projects only, but there are many more in the pipeline being discussed, put forward. We want to make this area of ELI's activity much stronger, as it is incredibly relevant at the moment. And I would like to also stress that we are an organization that is political. Our power is a power of argument, and our impact is of this nature that if we provide work of excellent quality, it speaks for itself. We do not work as lobbyists. We are the experts. And I don't think there is any danger danger that would arise from the analysis that we provide. And of course, the subject we take on board are topical subjects and subjects of relevance. So they will necessitate this political reflection, because hopefully we choose something that is of interest for the European Union, and we can impact the European Union by the excellent work that we provide them with. That being said, thank you very much, because I think this panel has provided us with this excellent input that we can work on further in the Ecocide project. Thank you very, very much. Thank you to the audience. Thank you our online speakers and viewers, and until next year.